Call the September 13th, 2017 Planning Commission meeting to order. So first order of business, agenda changes. Anyone have agenda changes, something they'd like to add or move around?
Just something at the very end. Doesn't have anything to
New
do
business.
with planning.
No plan, okay. All right, we'll move on to number 2 then, public comments for non-agenda items. Unfortunately, we have nobody in the audience, so we'll move on to item number 3, zoning and subdivision. So I think the plan was to go to 5.9 and then to skip up to 521.5.
Right. So we're just picking up where you left off at your last meeting on the 23rd of August. And if you have that zoning regulation, or sorry, regulation revision summary document in front of you, it goes through all the various changes. And as Joe mentioned, we skipped over 5.9 having to do with accessory apartments to allow for Rolf and Marie to be here, because Marie's interested in this, and Rolf actually was the one who helped prepare the language for this. So section 5.9 in the zoning, I will flip to on screen, and it deals with accessory apartments. And rather than put Rolf on the spot, I'll just tell you what he proposed, and he can flesh out the rationale. But essentially, our current regulations has a size limitation that is somewhat restrictive and based on, partially based on the original state statute, which says you have to allow at least 30%, you have to allow apartments to be at least 30% the size of the home. You can cap it at that, but you can't make them be any smaller than that. When the Planning Commission last touched this section of the regs many years ago, we stuck with the 30% and we added an additional caveat that if you had a very small home, you could at least get 660 square feet. So you would get the greater of 30% or 660 square feet. Well, we've had a lot of feedback over the years that it's difficult for folks, especially people who have aging parents who would like to move into an accessory apartment situation, to live in a accessory apartment that small. So we looked at some other communities, and Rolf came up with the proposed language which boosts it and says that instead of the limit being 30% or 660 square feet, it's 50% or 1,200 square feet. With an additional proviso in the sentence that says, furthermore, in no case shall the accessory apartment exceed 75% of the total floor area. So what this basically does is it just ups it. It allows accessory apartments to be larger, but it does require that they not exceed 75% of the total floor area of the dwelling. And so it's a little, the way it's worded and the what we're trying to accomplish is a little difficult to understand in those two sentences. So I added these 3 bullets.
Get rid of that?
We could actually. We could just have the bullets that sit below it. And that might be a simpler way to say it. So the bullets below that give you the actual sort of examples. So if you're a large house of 2,400 square feet or more, your maximum apartment size is 50% of your house size. If you're in this middle range of 1,600 to 2,399 square feet, the maximum apartment size is going to be that 1,200 square foot cap. And if you're smaller than 1,600 square feet, if your home is, maximum apartment size is going to be that 75% number. So that's not a bad idea, Dennis, to get rid of the first 2 sentences and just have it be the bullets. But before we do that, does everybody understand what's happening here? And Rolf, do you want to say anything about this, or are you happy to?
Seems like 2014. I'm just, never mind. Not anything profound. I think, it seems as if the accessory apartment idea is meant to address, mother-in-law apartments, some kind of supportive structure, and the notion of it being 1,200 square feet, that's not crazy as a dimension, and seems to offer the flexibility of it could be a 2 or 3 bedroom accommodation without too much trouble.
Well, it says it can only be 2 bedrooms.
But it is limited to 2.
Yeah, we haven't changed that, so the 2-bedroom limit is still there, but definitely would add the ability to do quite a lot more square feet, which is the comment our office has gotten from people who have explored this.
Now,
That-
is this living area only?
Yeah.
Yes,
It doesn't
Yeah.
include garage.
we've
You
had
build a
cases where
garage and
folks
all
have
that right above
had
it.
had garages integrated with a accessory building, and those don't count towards this square footage limit.
I mean, as I remember, I think at some point in just thinking about this, we just sort of, we went to 1,200, and I think that's discussable in my mind. That may be a little big, and it also depends a little bit on configuration. If you've got a series of just 1,200 square foot, 1-story buildings, is there some scale issue with the predominant structure,
I'm trying to think, the first condominium I owned was 1,000 square feet, 2 bedrooms. Right?
Yep.
So 1,200 is big, but then, if I happen to have a 5,000 square foot house, which I don't know anybody that does, that's a 2,500 square foot accessory apartment, is it?
Right, but you wouldn't allow that because you can only have 75%.
Yeah.
So
But if you-
that addresses that issue that you're.
Furthermore, no case shall.
No,
the
for the
accessory
larger
apartment exceed
homes, Joe's
75%.
right, the 50%
can.
is the
50%.
limit. So if you had a 10,000 square foot home, you could have a 5,000 square foot
Oh,
accessory
okay, I'm
apartment.
sorry, I misunderstood
But that's
that.
true under our current regs today. Not that our
Right.
current regs are sacrosanct or anything, but if we currently have a 30% maximum, if you have a 9,000 square foot home, you can take 30% of that, so, and have that.
I think that does get away from the idea, in my,
We don't have much of that in Hinesburg,
No.
though, I will
No,
tell you.
don't,
I
but-
can only think of one house
You'd
that
hate to
maybe
see-
approaches 8 or 6.
you'd hate to see a 5,000 square foot accessory structure.
So it wouldn't be
With
difficult.
2 bedrooms.
It wouldn't be difficult to,
Man. Not
likely it'll
to
happen.
put an absolute cap on the
True.
size, to say
Right.
you're granted this much and otherwise it's a percentage with a cap of whatever.
Right,
If you feel like you're getting too much the new homes being built versus accessory apartments.
You could just say, you could leave that one sentence in there, the accessory apartment shall not exceed 1,200 square feet,
or 1,500.
or whatever.
Alex and I had a little discussion about it in the office, and he wondered if I could tell how many there already are in town, and we don't really have a way to do that, but his gut feeling was no more than 30 existing now, and I was somewhere thinking between 20 and 30. So it's not something that, even when we increased it, when you increased it before, it hasn't gone out of control. Do you know what I mean? Follow my train of
So if
thought?
you had an attached garage and you built an apartment upstairs, that wouldn't go toward
That wouldn't count as an accessory
accessory
Yeah.
apartment?
No, it would,
If you had
If it wasn't
an
connected.
attached garage
yeah.
and
To a
you
house,
built
primary house.
attached to a house and you built an accessory apartment above the garage, you could do that. It's all one structure. The house, the garage, the apartment is all one structure.
Right.
But the garage would not count towards the living space of either
Just upstairs.
the apartment or the house. It's not living space, it's a garage. We don't count garages as living space. Same way with unfinished basements, they don't
But
count.
upstairs would be.
But would the upstairs be considered an accessory apartment or just part of the primary structure?
So what defines an accessory apartment is not its size, but its means for independent living. So to be an
Kitchen.
accessory apartment, it has to have a kitchen, a bathroom, and a bedroom.
And its own entrance?
And its own entrance, exactly.
Right.
So if it has all of those, then it needs a permit as an accessory apartment. If it's just additional living space, a bonus room above the garage, and it happens to have, a bathroom in it and that sort of thing, then it wouldn't be an accessory apartment, it would just be part of the house. Yep.
And we have both in our town existing
Now,
now.
accessory apartments, if you have a 4-bedroom house, or do you have to deal with the state, can you take 1 bedroom from the house and put it to the accessory apartment? Or do
Yeah,
you
the
have to
state-
call the state?
You need to talk to the state. We require some kind of coordination with them to demonstrate that your septic system can handle the additional bedroom or 2 that the accessory apartment would be adding. But the state's been very, liberal, easy. They've worked with people to allow them to decommission a bedroom in their house and grant, and sort of cede it to the apartment, and so as not to have to increase their septic
So all you have
system.
to say is you're not using it as a bedroom, or you gotta turn it into something else?
Yeah, unfortunately, it's a gray area. The state basically just says, we're gonna issue a permit or give you guidance in a memo form that makes it clear, without the homeowner having to do anything special to the bedroom. When Peter was here as our zoning administrator, he wanted something physical done to that bedroom, either take the door off, do something to make it so that it wouldn't function like a bedroom. We've had we are now 2 zoning administrators beyond Peter, and Suzanne hasn't been presented with that issue, and Mitch, I think, had a slightly different, more lenient take on it. So, we could specify that in the regs. I'm not sure it's worth doing that. Household sizes are so small right now that what I tried to explain, I think to Peter or Mitch, I forget which one now, is that it doesn't worry me that somebody is going to officially have to get rid of a bedroom and then maybe not, because the septic systems are based on bedrooms, but the designs assume that there are going to be people in all those bedrooms. And household sizes are so small these days, there are not people in all these bedrooms anymore, so.
Alex, don't they also assume 2 people in each bedroom?
Yeah,
Which is very rare. Usually, there's only 2 people in the first bedroom, and the other ones, there's 1. That's what Mitch has told me.
yeah, that's right.
We've had some lengthy discussions about that.
Yeah. But
And I think he's
the short
right.
answer to your question is the state will allow that to happen, and they won't require the homeowner to really do any deconstruction of the bedroom that they're losing in the house. But at our level, we've required some kind of demonstration that it's no longer a bedroom.
Okay.
Well, I really like this wording. I'm for accessory apartments, and I will say that personally, I have experience with it. It's worked really well for us and our family, but up until now, the largest we've been able to go is a little over 900, and it's still not quite big enough.
So do you think 1,200 is a reasonable ceiling? Or do you think we should stick with some
I like-
percentage of larger
I
house?
like the way you wrote it, first of all. I really do. I like these bullets. I was a little confused about the first sentence, and I asked Alex before the meeting. The other thing is, too, the affordable housing people are very supportive of accessory apartments right now.
Sure.
And I don't think that it's been abused by any means in our town. I think there are certain people that it works for, and
Yeah.
that's it, I just.
No, it's a great way to increase density and, it's just a win-win for everybody.
Yeah.
So anything we can do to encourage it, I think.
Yeah, I agree.
So I think the way the statute is written, this is why I wanted to look up the statute on this. I think the thought that there should be a cap, like, people should be allowed at least this much, but we shouldn't allow for 5,000-foot accessory apartments. I don't think that we can actually do that. I said we couldn't. I don't think we can. What the statute says is that any zoning regulation, I have it up on screen here if you can read that. Any zoning regulation has to allow for accessory apartments, and provided that they are in compliance with the following that are highlighted. So it has to have sufficient wastewater capacity. It can't exceed 30% of the total habitable floor area of the dwelling. and applicable setbacks, apply. If you go on to F, it's in F1, it says, this section shall not be construed to prohibit a bylaw that is less restrictive of accessory dwelling units. This is where we can allow for a lot more than what this says. I don't think we can allow for less. So I think the way this is worded is, if it says that you have to allow an accessory unit that does not exceed 30% of the total habitable area, if somebody has a huge house and they're only gonna use 25% or 30% of it for an accessory apartment, I think we have to allow the huge apartment. I am happy to go get a legal opinion on that, if you are interested in capping, the size of these things for very large homeowners. But that's my initial take, is that actually we can't really cap it, unless it's at this 30% rule.
I mean, it seems, accessory apartments that large seem kind of absurd, but I'd have to agree with Marie that the likelihood and use of that
Is remote.
is probably not worth the time it would take
Yeah.
to craft the language to stay within 30% for the bigger,
Right.
your thing. I
I
think,
agree, and honestly, I can tell you, there's not a lot of houses in town that hit even 4,000 square feet. I can only think of one that is more than that. Most of them are way under 4. Most of them don't go over
Over 3?
3.
Then let's not worry about it.
That's
That's fine.
that's my
I-
thing.
Well, that was the
think-
only thing I was worried about, was the 50% of something really large.
I
You
think
have a
I would,
10,000 square foot house, you could have a 5,000 square foot accessory structure.
I'd be shocked.
yeah, I think I would take away the paragraph ad and leave it to the bullets.
Yeah,
The
Okay.
bullets, I understood in the first read. The paragraph,
yeah, I was confused about
right,
that.
and comparing to the bullets took me a while long.
Alex, the screen that you just had up there,
Yeah,
is that the state?
yes, that's the
It
state
says
statute
an accessory
governing,
apartment is an efficiency or one-bedroom unit.
right. So, this was a big conversation when this statute got revised back in 2004 or so. And it's been my understanding that section F1, that says a bylaw that is less restrictive of accessory dwelling units is allowed, allows us to do more than one bedroom. Some people argued that that's the actual state definition, and you can't monkey with the definition, but others said you could, and we did. So back when the planning commission updated this in, 2005 or so, at that time, we made the call that we could do it, and we did.
And I do believe that there's several other towns that have done the same thing.
That go
'Cause I
beyond the
did
one
go to-
bedroom.
At one time to many towns to see what they said. And that's my recollection.
But that's a good catch, Barbara. That was a
Well,
topic
and
for much
What
discussion.
about, the water? And it says wastewater.
Yep.
If someone wants to build this in the village,
Mhm.
can we provide the water and wastewater, or they have to prove that?
Well, they do because, per our water and wastewater allocation ordinances, you can't get one without the other. So because the state statute just refers to wastewater, in our village municipal service area, it effectively means both. Yep.
And I think at the state level, it actually does mean both, because I
Well,
dealt
you-
with that last
You
year.
you would need a state permit, a wastewater and
Right.
water permit for a new accessory apartment, and you wouldn't get that, unless there were both water and wastewater
Right.
available, which we don't have at the moment, or not very much of.
But don't we have some free for things like that?
We have wastewater capacity. Right now, we're not giving out any water
all.
allocation because of the problems the system's been having on a short-term basis. If those problems resolve, we would have a very small slice for things just like this,
Yeah,
like an
that's what I
additional
thought.
accessory apartment or minor business expansion, but not enough for any big new development until we get a new well, which we are working on.
So Alex, I've got a 4-bedroom home,
Yes.
and I have a permit for those 4 bedrooms in terms of waste disposal.
Okay.
And I'm gonna take one of those bedrooms, and I'm gonna make a small addition to it to get a kitchen. And it's gonna be a studio. I already have a permit for 4 bedrooms.
Yes,
If I say 3 of them belong to the primary structure,
Mm-hmm.
and the one that I've converted into an accessory accommodation, I don't have to get a different permit for that.
Correct.
I already have it.
yes, so, yeah, and that does happen. People will, instead of creating an accessory apartment in a new structure or a new addition, they'll just convert part of the house and put on a exterior door and call it
Right.
good. Yep, you don't need any wastewater permitting for that.
Okay.
You still need a zoning permit,
Yeah,
for the accessory apartment use, but, we don't require you to go to the state again for
for
wastewater.
the wastewater.
Yeah, cause it's still 4 bedrooms and, then yeah,
But there is a caveat to that, and I
What?
can address that. When we built our accessory apartment in 2002, they didn't allow that, and you had to have your own system for the accessory apartment. So when I added,
Use the plumbing
I
that
could
was
not-
there already,
in my house, nope,
that
we
fed
had-
into a waste disposal
but that was
system?
2002.
Right.
The state wastewater rules changed
Right.
right after that and
right, so
lots of
we
other things
had to,
did
we
too.
built our own, we had to build a new one and get a new permit. So when I added on, I had to go back to the state and re-permit, amend the permit for the one I had. I couldn't go, I have 4 bedrooms in my house, and we use one of them,
Right, it's just 2 of you.
because there's just 2 of us. But we couldn't go to the house. We had to stay with what we had,
Right.
so. And I'm sure there are others like that in town, not just us, but.
Okay, well, I think I got it. If everybody's on the same page, it sounds like you are. Strike the first
I
part,
assume
keep the
that all of
bullets, no
this-
cap.
All of this is allowed to be a father-in-law's apartment also, right? Seems we're always
So,
talking about mother-in-law's
So
apartment.
that's
What
interesting.
happened to
The
father-in-law?
reference to mother-in-law apartments is an artifact of the past. My understanding was that way back when, the accessory apartment provision in statute was related to relatives only. And they may have even been officially called mother-in-law apartments. Father-in-laws were maybe excluded. I don't know. No, I'm just
Or
kidding. But
prodigal sons, for
Right.
example, that
But
there
when
are
the,
more
when
of
the
these
state
days.
did a comprehensive rewrite of the state statute for planning and zoning in 2004, so this all got updated, and so these are, there's no relation necessary, these can be purely rental situations. The only thing that we require in Hinesburg is that the owner of the property lives in either the house or the apartment, so that they don't become both rental house and rental apartment.
Yep.
So yes, father-in-laws are fine,
Okay,
as are struggling college students
Right.
or
prodigal sons,
prodigal
daughters.
sons. Yes.
All good.
Okay, do you want to move back into the
That's right.
521, 5?
Finished 520, didn't we?
Oh, actually, there was one other thing that we needed to do in accessory apartments, just so Maggie doesn't accuse me of sneaking anything else in. So in 5.9, what other changes did I put in there? There was the size, oops, sorry. Right, so number 5 says, currently the language says, no additional access drives are to be created. And so that's, we've interpreted that literally to mean, the accessory apartment, if it's gonna be in a separate structure, like you wanna build a garage with something over it, you have to come off your existing driveway. It can be anywhere off your driveway, but you can't, like, if your property has a lot of frontage and you wanna put in a new driveway, you can't do that. So this proposed change would eliminate that, on private roads. So that we're saying on the public road where the town has jurisdiction over access, permits and has maintenance responsibility for culverts and ditching, no new access drives for accessory apartments. But if you're on a private road like Obie Ridge or, Partridge Hill or Red Pine, or there are lots of private roads, there you go, then that wouldn't be a prohibition. You know, you'd have to talk to your, it would have to be okay with the easements that you had along that road if you have an association or within your deed, but that we wouldn't police that. So this is a choice. You don't have to change this, but it seemed to me, we had one person who was in front of you for another section of the regs that was problematic for them on Partridge Lane and Red Pine Road, or Red Pine Lane. And he has a similar situation where he's got a very long parcel with lots of road frontage. He's got a house on one corner of it. And in one of the many discussions we had, he said, okay, well, I can't subdivide it. Can I at least put an accessory apartment? Like, it's just gonna be right off of the road. It's, you know, it's not gonna be a long driveway. And I said, no, because that's a separate access. The only place you can put an accessory apartment is off of your house driveway. And he said, well, my house is on the one part of the property where nothing else can go. So how do I use my other 10 acres? I said, you can't. So anyways, I thought this would be a reasonable change, but it is a policy change, so you need to
What about
talk
class
about it.
4 roads?
This, as drafted, would say no additional accesses off of public roads, so that would include class 4 roads. It would only give this special dispensation for an additional driveway cut on private roads. Which we don't manage, we're not responsible for, but we do, when it comes to general zoning dimensional standards, still require frontage and setbacks and all of that. So there are parts of our regs where we consider private roads and require things around them. What do you think?
I'm okay with it.
I'll just, before we move on, in deference to Peter again, we can't, Peter will be here for a long time. He was instrumental in getting this provision put in the first place, back in, I think, 2005, because he was concerned from a policy standpoint of people developing sort of separate homesteads with accessory apartments. He kind of felt like accessory apartments should be proximate to the dwelling.
Yep.
And thought, well, if you allow one way far away, then it's sort of like having a second house site. And so this did help stop that to some extent. Some people do have very long driveways and then they can still get away from their house. So just know that that's a possibility. You know, if you allow a second access point on a private road, then someone who has a lot of frontage could have very much two different developed areas on their property.
So this was, they came in here, right? The Partridge Hill?
Yes, yeah, I forget the fellow's name, but
Because I remember that map went up. So he wants to do a rental, is that?
he was just exploring all of his available options. Like, I think in his case, he literally had a friend who wanted to buy like some land and build a house. And so that's why he was initially thinking subdivision and was like, well, that's a problem because you've got all these right-of-ways and contiguous area requirements. And then he said, well, what about an accessory apartment? Can I at least, build that and rent that to him? And then I was like, no, you can't do that either because you can't make another access. So that was just one example.
So how far away from the residence could the accessory apartment be?
So as this is drafted, there wouldn't be a limit. So if you had
On a private road.
on a private road, if you had a 100-acre parcel and somehow that was accessed by a private road, there aren't very many of those. If you had a 20-acre parcel and you had a lot of road frontage, you could have your house on one side of the parcel and, 600 feet down the road, you could have another driveway coming into an accessory apartment.
Because I have to remember that conversations during the rural area zoning about, the 10-acre lots and, especially, I think we were talking in the North Road area and just how already chopped up and how, that death by 1,000 cuts kind of thing.
Mhm.
Well, if you're concerned about this, number one, I think there's some economic, reasons that somebody would not do this, sharing of septic, sharing a well, et cetera. But, if it's perhaps a concern, make it a conditional use or put it on, put a limitation that, the dwellings need to sit within, pick a number, 100 feet, 100 yards, 200 yards.
That was the discussion we had way back, Joe. You probably remember a little bit of it. We had that discussion of should there be a radius, proximity to the dwelling? Should it be just new access is prohibited? And then
Or sharing the septic system, is that reasonable?
Why is it an issue if they're far away? I mean, what difference
Well,
does it make? if
yeah,
it's a
so
private road?
for the record, I never thought that was an issue. I'm just
Right.
bringing it up because
Yeah.
I know it was a policy
And-
issue that Peter had raised and the commission
Right.
had bought into, and that's why this provision was put in. I don't think it's an issue. I don't think we have
Right.
enough of these things
Me too.
to change the development pattern of Hinesburg as a result of seeing accessory apartments off of separate driveways. Because like Joe said, most of these go right next to the house. Many of them are above garages or associated with accessory structures that are, again, near the house. And,
Well, it's
I
just that
just-
we
I don't
had
think
this
it's a big
conversation
deal.
and we decided to close that envelope on subdividing those.
smaller lots,
Yeah.
yeah.
And we did that for a reason, that, death by a thousand cuts thing. So when you talk about a longer lot that would be doing exactly that, I mean, to me, I see the accessory apartments as such a win-win because we can increase density without, basically without,
Without a big development footprint.
yeah,
Yeah.
exactly.
And that only happens if you do it in proximity,
Using the
yeah.
same driveway,
Right.
in many cases, using the same building that's already there. So, yeah, I guess we're essentially talking about, and I'm sure it hasn't really come up, but, we're essentially talking about that, about subdividing a lot, which you can no longer do. But you can apparently if we,
Well, I mean, there are some differences between a subdivided lot and a separate principal dwelling versus an accessory apartment, I think. Of course, you're
Yeah.
allowing these to be larger now, so the difference starts to blur a bit more.
I think if you could subdivide the lot, then people would probably try to subdivide it. If you can't, people will maybe ask to build the accessory, possibly. But usually people build the accessory for a reason that they wanna just build the accessory.
right.
So I think, honestly, I don't see that, has
think that
anybody
the-
ever come in and said, I wanna take my accessory unit and subdivide it? I've never heard of anybody do that in all the
No,
years
and
I've
I
hung
don't, I don't
around.
think that's what Maggie's concerned about.
No,
I
I-
think you're concerned about the end result sort of looking like that.
Yeah, it's, if,
Right.
if someone is, has one of those longer lots and is, it looks as though it's subdivided because
Right.
you
It's-
have a separate driveway entrance, separate parking area,
Yeah.
separate building. It's as good as
Right.
subdividing and having two structures. Whereas, and I don't think that really fits the, definition of what we're doing here, which is
Right.
increasing density without increasing footprint, basically.
And like Joe said, that gets really expensive to do it. Roads are
Right.
expensive to build today. I just can't imagine someone is gonna build an accessory unit.
Aren't a lot of our lots have building envelopes in them?
Yep,
Well, a lot of the ones that your board, the development review board sees end up with building
So
envelopes.
they wouldn't be able
and
to
they-
go out of the building.
Right, you'd be stuck in the building envelope, for accessory apartments. But most lots don't. Most lots in Hinesburg, haven't been through the DRB review and don't have a building envelope associated with them. But I think that the concept that you're talking about, Maggie, makes sense. It's logical. But the analogy to a death by a thousand cuts with perpetual subdivision, I don't think there can be any death when it's only a dozen cuts. Like, we just don't have enough of these accessory apartments. There's just not enough interest in them and actual construction of them for it to ever become an issue, in my mind, because the vast majority of them end up building near the house anyway. And so it's a small fraction that would even take advantage of building a brand-new driveway. And the number of accessory apartments that we see is just such a small number, so a small fraction of a small number means not that big of a deal. But I agree with you that it does open up more areas, on the landscape to development that might not have otherwise seen it.
I mean, it's, I don't know, I mean, it's possible, and I don't know financially whether it would be worth it, but, maybe rental, you know,
I think a lot of people come in and even talk about, or even sometimes get a permit to build an accessory unit, and then they never do it. And my gut tells me that they find out how expensive it is to do.
Some of it's that, some of it is the square footage cap that we've had.
That's true,
I've talked,
too.
I've definitely talked to
Limits.
at least a half a dozen
Yeah.
people who were seriously interested, and then later on, I
Yeah.
was like, why didn't you do that? And they're like, yeah, it's just too small.
Right.
So, hopefully we'll see some more
Yeah.
with the, square footage limit increasing. Yep,
I agree with Maggie, I think we should have a distance 50 feet away, something like that.
I disagree. I don't think we should.
Well, 50 certainly wouldn't be enough, because the one I have is 200 feet away, and it's really close. It's like, not, 200 feet isn't very far.
yeah, I think every lot's a bit
I mean,
different on
not
that
to-
front.
That's just my comment on it. So you gotta figure out, if you did that, what would be the appropriate, because even 200 feet isn't very far.
what's your objection to the distance thing?
I just think, I mean, I got a perfect lot where I could build an accessory apartment off my driveway. I mean, I have 40 acres. You come up around the corner and be out around the back, it'd be a lot more than 50 feet from the house, but no one would ever see it. You know,
Well,
it
and
just-
you're, have any of you been up Dennis's driveway?
We're still waiting for the invite for the barbecue.
Sugaring.
Anytime.
Sugaring. You really should have a planning commission meeting at your sugar house.
That'd be cool.
Can you fit us all?
I just think it's, not everybody has land they can do it with, but
Right.
it's
Well,
just perfect for kids, you know, if they wanna have
What I was gonna say about your driveway is Dennis has a very long driveway.
800 feet.
Yeah. And along the driveway, there are various accessory structures. You know, he's got a barn and then there's, I don't know how many you've got. You like to have structures. So a distance away from the house would be odd because he has development all along the driveway for sugaring and workshops and that sort of thing. And any one of those could be an accessory
But
apartment.
that's on the driveways.
Right.
It's on your driveway.
Right,
not-
well, this is why, way back when, we chose not to use a radial sort of distance measure, and we chose to limit the number of access points, because these same conversations came up. But you could do it, maybe it just needs to be more than 50 feet, or maybe not.
He's not very far.
Maybe it should stay exactly the way it is, no additional access.
So how, but if, because that makes sense, if you have accessory structures, why not turn that barn into an, you know, an accessory structure, but it's on your driveway. So maybe the issue is,
Back to-
no additional access points to a public or private road should be created. If it's on your driveway,
Right, but I could still come off my driveway and go out into my pasture,
Right,
I don't know, a long ways.
But you're not going onto a public road. you're
No, I'm
saying.
not going on a public road.
Right.
This isn't, the way this is worded, this isn't a public road either. I mean, this is a private road, which, I mean, to me, my private road is like my driveway. It's just an extension of my driveway. I gotta care for it, I gotta pay for it, I gotta plow it. All right, it's my driveway. Now, I can see legitimate concerns here about, you know, breaking up contiguous area, you know, open area. I mean, we've had that concern with rural before.
But it's all under
But-
one ownership still.
maybe what
Yeah,
Maggie's
but-
getting
You know what I
at
mean?
is
It's
not, how far away or which access you come off of, but how much land is consumed in the creation of the apartment. Maybe there's a way to limit, if we're just talking about access, the length of new driveway added to facilitate access to the accessory apartment, or something like that, because I think Dennis's point is a good one. Under the current regs, so if we didn't change anything, it would say no additional accesses are to be created. So he could come off his driveway and make an apartment in one of his existing barns. Everybody would look at that and say, great, it's an existing building, it's right on your driveway. But he could also punch a new driveway off of his existing driveway
Right.
and go out 700 feet and plop something down in the middle of a pasture, which is sort of not what you want to see happen. So the current language doesn't prevent what you don't want to see happening. The proposed language doesn't prevent what you don't want to see happening, but maybe something that's more specific about, we want these things to have a small development footprint, so let's define what that is and say you can't exceed that, might be the way to go.
Maybe it has to do with the personality of the mother-in-law.
What about the prodigal son?
Alex, what about a situation where you have 400 foot of frontage on a public road, and you have a driveway to your house, and you'd like to build an accessory apartment, and your house is at one end of that 400 foot of frontage, near one end. What if you wanted to build an accessory apartment near the other end? What this makes you do is build another road
Right,
off your
driveway.
parallel to the existing road,
to get.
cutting through what otherwise could remain as an open field, which you might let a farmer hay.
Right,
Now you're saying, no, you can't go 50 feet onto that public road
yeah.
and make a short driveway. It's gonna require another access point. You can't do that.
Yeah, so any one of these scenarios, Maggie can paint a picture that doesn't look good, Dennis can under the current regs, and you just painted a picture that either the current regs or what's proposed still make something weird like that happen
Yeah.
in the extreme. Like, most of the time, this isn't gonna come up, but it could. So again, if the concern is development footprint, maybe that's where the limitation should be and not accesses or what have you.
I mean, I don't wanna, you know, drag this out for what is essentially, you know, not, right now, not a lot of, you know, there's not a lot of this happening, but we are increasing the sizes, so.
Right, we will see some more
We're
because of
hoping
that.
that, we- I mean, that we will see more, because that's why we're doing this, we wanna see more.
And I think the distance thing, you know, I see it as difficult to sort of construe rules that, on the one hand, I understand the latitude. On the other hand, you know, I think behind all of this, the notion is that we're still talking about some compact form of development. And so to see, just as we would probably encourage some kind of concentration in a subdivision and its development, at least within certain areas, even when it comes to an accessory structure, you somehow associate that with some kind of proximity as opposed to great distance, added infrastructure, that somehow seems to flaunt the intent.
And you'd end up with a 1,200 square foot building instead of, okay, then I have to subdivide, now you probably end up with a house and a garage and.
Well, it's kind of like the extended outbuilding, you know, that's sort of a tradition of the kind of architecture that you'd often see in this part of the country, you know.
But since there is no longer a requirement that the accessory structure be occupied by a relative,
Yeah.
I could build an accessory structure for rent. Right.
Yeah.
Which is
And-
fine, because
Andrea
it
Morganti
increases
did that right
density.
here in the
Right.
village above her.
And maybe I
barn.
don't want that renter
Right on
right
top of you.
near my house.
Right, that's what.
I want it at the other end of my long frontage, but I would have to not only build that accessory structure, I'd have to build the driveway
To it.
that would essentially parallel an already existing public road. Is that what we want? I mean, there was a situation that the land trust was selling some lots, and we tried to make and it was off of a private road, and we tried to make an agreement with an abutter to use essentially their driveway as the access, and they initially said yes, and then later said no, so we ended up having, when we sold that lot, having to build a very long driveway next to their driveway in order to get to that other house. And it's cutting up our open land. I'm not talking about the building structure. I'm talking about the road and how it impacts our open lands. Do we want to encourage that? Yes, it's expensive to build that for the landowner if they have to build a long driveway to what would have been a very short driveway could they have connected to a town road? But we're saying, no, you can't do that. The only way you can do that is subdivide.
So John, you've pointed out a problem with both the existing and the proposed line. Do you have a suggestion for how to deal with the intent of number 5?
Only that we might consider some other language or another concept to approach that. I just see problems with it the way it is. I don't have language now in my head to
Okay.
solve
Al-
that.
Alex, why can't we go back to the fact that it has to come off of your driveway? I mean, isn't that how it was before? That
Yeah,
you
we've-
couldn't have a separate road, it had to be an extension somewhere of your existing drive, correct?
Yes, but John's example is still
saying that's
valid.
the problem.
We've had situations where someone said, all right, once I get onto my driveway and I want to put in my accessory apartment, is there a
Go
limit
to-
on how far the extension off my driveway is? And we said, no, this language
Okay.
just says no new access points. Once you're on your driveway,
Okay.
we
I
said you
didn't
can build,
envision
you can
that.
build it right next to your driveway, or you can build it 200 feet in, from your
Okay.
driveway.
I didn't vision that when he was talking about it. That would be very unsightly, in my opinion.
It just
Yeah,
depends,
I mean,
like Dennis said, in some cases, it wouldn't be, because you'd never see it, and in other cases, it would be, in some cases, it would impact a resource area, in other cases, it wouldn't, it all depends.
And it doesn't, what I'm suggesting is we don't need to say you can't do that, but this is the only option, is what we're saying. The only way you can get to an accessory apartment is by using your driveway and coming off of that. You can't come off of the road, the town road.
Right, that's what I meant.
So,
And-
Alex used some interesting words. Resource area, so if we think back to what this board did, for agricultural and forestry, when we think about where things like this are going to occur, it's gonna be R1, R2, ag, where this is gonna happen, right? I mean, maybe language like you either put this building in your current envelope, or, right, you cite it in a way that is consistent with, all of our citing regulations for, the R1, R2, I should really say ag and forestry. You cite it that way, so you minimize resources and you minimize impact.
That would begin to address my concern.
Right?
Why don't you let me work on some language then, because I think you could continue to kick this football around, and I can draft something then, so that the next time you see this before we go to a public hearing, it's got another discussion item around this.
Right, I mean, you could even just, you could even take, that citing and say, okay, well, if you use a single driveway and you keep it within the present building envelope, that's permitted, and if you wanna do something different than that, that's conditional, and here are
Yeah.
the things we're concerned about.
I think that the way this is structured now under 593, which is at the bottom of the screen up there, conditional use approval is required for any new accessory structures that are gonna house an accessory apartment. And so that would be a good place to just
Yeah.
fold that in and say, part of that conditional use review will include the citing standards in section 5.23. We have a section that talks about the rural area zoning, and we could reference that.
Yeah, I think
Then you wouldn't have to
everybody-
pick a development area or a length of driveway, it would all just be resource-based.
Yeah, I think everybody at the table is making good points, and what that tells me is that there are a lot of variables here that, it's very easy to get an undesirable outcome with a single set of words.
Yep.
That sounds like a great solution,
agree.
yeah.
Because everybody's lot is different.
Yeah.
Exactly.
Yeah. Okay. James, you said that you thought we still had some more to go on the camping section.
Yeah.
I thought we had finished that,
I
but,
don't remember talking about that at all.
okay.
Which section?
5.20. Does anybody remember,
Well, I made made a note to start with 5.20 on today.
All right, well, maybe I got my notes mixed up then. I thought we had
sorry, we
talked
have to go
camping.
with minutes.
That's right. What do the minutes say, Don?
And we definitely talked about camping. I
Yeah, we
remember
did.
talking about camping.
Maybe we were
All right.
like going into details about yurts or something.
Well, we have a few of those.
I guess I'd like to say, can we say a little more about it? I just feel like it's quite strict. I mean, I can imagine, you know, enjoying camping myself and having some friends over more than 3 days a year to camp. And in that case, say there was four tents, 4 times, I would have to be a campground.
Right. Yeah, that's a good thing for you guys to talk about and understand, because there's no magic about that, but that is the way it's drafted, is to say that once you have 4 or more camping units for more than 3 days a year, we're gonna call you a campground. You're gonna have to get an approval as a campground. So if you wanna strike that or change the number or whatever, we can do that.
I guess if we're gonna have a number, I would suggest maybe we think about a hunting camp and say, well, more than a hunting season, so maybe like 15 days.
Well, so 2 things are going on in this section. One is it's defining camping and saying that if you're camping for X number of days, you either don't need a permit or you do need a permit, and then there's an overall limit of, you can't do it for more than 180. This section is just trying to cover the situation where somebody's not camping for very many days during the year, but they have a de facto campground. Because they have so many people camping on their property, I don't think you want to have that situation happening where neighbors are like, what can I do? And you're like, no, it says as long as they're less than 90 days, they don't need a permit. So maybe this number 3 section just needs to be changed in regards to how many camping units or how many days would trigger trigger you tripping into campground status.
We could do a camping unit day.
I suppose you could.
I guess I don't have a, specific number, although it made me think about hunting season, like, hunting season seems like a time when somebody might come out and use their RV for 14 days of the hunting season.
Right, but you wouldn't typically see 3 or 4 RVs on one site for hunting, right? I mean, you'd see people piled up at a camp or,
But there's one lot on Pine Shore Drive.
Sure.
That does not have a house on it.
Yep.
The people from Connecticut owned it for as long as I can remember.
yeah, and
And
they
they
came
came
for the
every
summer.
summer and camped out a lot of tents, I think. I never went up there and looked. And they had, portalets, and I don't think it was ever a problem at all.
No, and so the idea behind this is not to trap those people, but this says occupied by 4 or more camping units. So if it's you and your buddy and you got 3 tents or you got 3 RVs, you're fine. But the moment you put the 4th one on, or you could change it to 5 or 10 or whatever, at some point it really does trip into a campground situation. And I think neighbors have a right to see some sort of review on that, with proper septic disposal in the whole
I remember
backyard.
they had excuse me. Well, and say you have a wedding.
I was thinking about
A
that.
family a lot of people have weddings now on their property. In the summer, when our son was married a few years ago, a lot of people camped out, like a lot of tents.
Right, so the way this was drafted, and again, there's no magic here, we can strike it or we can
Right.
revise it.
Labor Day or
Yeah, so Marie, this says it has to be 4 or more units,
Yeah.
RVs or tents,
Yeah.
and it has to be for more than 3 days a year. So if
That's a little
it's, two friends camping for 10 days, or it's, 15 people camping for 2 days, it doesn't trigger the campground issue. So we can strike it, or we can tweak it to say it's gotta be more than 4 units, or that it has to be more than 3 days, so that you don't trap the people who are coming up for the weekend wedding.
Right.
You know, I mean, if I just think about summer, right, there's a long weekend at the start of summer, it's Memorial Day, and there's a long weekend at the end of summer, you know, Labor Day, and if you have a large piece of property and you like to have parties on Memorial Day and Labor Day, right, you're at 6 days, right, and if you want people, you know, it's kinda, it's just strict.
Yeah.
Well, like I said, we can get rid of it altogether if you want.
It just that hasn't been a problem yet.
No, this whole
Yeah.
section was completely revised though, and so we're just trying to cover all of the potential bases and not have, because you're being very permissive with not requiring a permit for camping vehicles up to
It's like 90 days.
90 days. I just figured there's a potential there for somebody to say, hey, I'm gonna have all my family come for 60 days and have 10 RVs
would
on
be
my
a long
parcel,
time.
and,
That
you
would
know,
be a problem.
effectively, that's the summer, and that's
Yeah.
like, that's a campground in my
I
mind.
agree with you there.
Yeah, I can see not wanting a tent city for the whole summer, or a
No.
camper city for the whole summer.
So for
If
the
somebody
wedding,
had a
how many,
small
how many
house,
nights were people camping
They have a
for?
big
Oh,
RV.
ours was only
They
2
might have
nights.
someone
2
come
nights,
up,
yeah.
friends or whatever,
But
come up every weekend, and somebody
Joe's
different
point was.
stay in that
someone
camper,
could
right?
come from-
Sure, it's not the single camper that this would ever be a problem for. It's the situation where a property owner is hosting, 4 or more campers all at the same time.
We are a rural town too. I mean, there's a lot of areas that it would be okay in this town and no one would ever know, hardly. I mean,
Well, you're in charge, so whatever you want this to say or
no,
not
I'm not,
say,
I'm just,
No, I mean you as a commissioner, are
yeah,
George.
I know, I just think it's a little too picky on, but. Like James said, 2 weeks. Did I hear you say 2 weeks? Deer season, that's a 3-week span of time, right? Every year about? Or 3 weekends,
Yeah,
is it?
most of the loading season.
Right,
I think
exactly.
it's
And
closer
bow
to 2 weeks,
seasons?
but 3 weekends, yeah.
But it gets pretty cold during that time. I'm thinking more of the summertime, but
Well, put bow hunting in there, and that's another.
that's
problem.
right.
Right,
I don't think
That would be
most,
generous.
right.
but
Well, so what would you like to do with this? Would you like to just get rid of it, or do you want to keep the protection but just up the numbers so that
I would
it
up the
doesn't
number. I
trap?
mean, we had a wedding this summer and we would have needed a campground permit if we'd been,
there you go.
Maybe 2 weeks.
Instead of 3 days, make it 2 weeks.
Yeah, I think that's, when he said 2 weeks, I kinda like that.
That's easy to do.
In 520.2 is where we say camping for 90 days or less doesn't require a permit. And after that, 90 to 180 requires a zoning permit. Well, I know a specific situation now where someone is building what would be considered to be a travel trailer. It will have a license, it can go on public roads, it has to be pulled by another vehicle, and they intend to live in that as their house.
Is that like
They're
a
a young
tiny
couple,
house? Is that like
it's
a
like a tiny house,
Okay.
but it's built on a steel frame that has a undercarriage to it. It's actually 3 wheels on each side. It's a good-sized vehicle, but it meets all the requirements for a travel trailer. But they intend to live in that for longer than 180 days. They would live in that year-round. It's insulated, it has a stove in it, it has a kitchen in it, it has a bathroom in it. All of these are self-contained. They would have to empty a container to get rid of the waste from the bathroom and kitchen. Right
So under
now,
our current,
they-
under the proposed definition for camping vehicle, that would not be considered a camping vehicle. Because that, if you see it on screen there,
Yeah.
it says a camping vehicle excludes mobile homes and small dwelling units on wheels, i.e. tiny homes. So they would not be covered by the camping vehicle section, and if they wanted to live in that unit, they'd need a permit, just like a house
Right,
or an accessory apartment,
or an accessory apartment,
right?
Because they're meant for long-term habitation, not short-term habitation.
right. But this is meant for long-term. Now admittedly, this is a young couple, they have no children, et cetera, but once they're done using it and build a house that's big enough to have a family in, I would expect that they would like to be able to rent that, or sell that to someone else to use as their house. So as long as that camping vehicle definition excludes them,
But I don't think they would get a permit if they didn't have a wastewater permit.
Yeah, it's funny, the state has an exemption for RVs for wastewater permits. So you don't need a wastewater permit if you're for an RV, because it's designed to, you know, bring to a dump station and all that sort of thing.
this isn't an RV in terms of having a steering wheel and a motor.
Right, it's like a
and
fifth-
self-propelled.
it's like a fifth
but
wheel
if
that-
it's attached to a vehicle, it can be brought to a proper
Right.
disposal station, et cetera.
So it's an odd thing, yeah.
I
And
have heard on television, they're talking about, people think these are grandiose ideas, but there are real problems in a lot of areas. Towns are starting to address it, and
the people that I know who are working on this have told me there are other people in Hinesburg planning to do exactly
I'm
the
not
same
surprised.
thing. So this is gonna be something
coming down.
that we're gonna have to deal with.
So the problem that could creep up here, under the way this is proposed with this definition of camping vehicle, is the reverse of what you're talking about. So if you're concerned that somebody who's doing what you're discussing is gonna be trapped in a camping, you know, definition and can only do it for 180 days, that's not the case, because this
Right, they're
definition
gonna-
excludes them. The problem is the reverse. If they have that and they say, well, actually, I wanna use it like a camper, can I do that? And this definition would say, no, it's a small dwelling unit on wheels. It's not designed for temporary living. It's designed to be a permanent, you know, abode. We can't give you a permit as a camping vehicle for that. So, you
But
know,
it's got wheels on it and a license plate, so you can move it to
Right.
some other location.
So this may need to be further tweaked, to indicate that these weird things that could serve either as a recreational vehicle or as a actual home.
Must declare like customs.
Yeah, or they cease
either
being a
end.
camping vehicle once they are installed in a location for a certain period of time, you know what I mean?
No.
That it's okay to use it as a camping vehicle
As
unless
long
it's,
as you
unless
continue
it's,
to use it as a
unless
camping
it's not a
vehicle.
camping vehicle, you know, if it's
And-
truly a house and you gotta get it permitted as
So what
such.
these people are gonna do is they're gonna start using whose ever land they're on, they're gonna start dumping it into their sewer system.
Right, it could be.
No, but that's how they're gonna
Right.
dump it.
Yeah,
Not the particular friends I know, but what you're saying is
Right,
true.
some people
Yes,
might.
that could be the way people dealt with it. Well, dealt with the waste disposal.
But Alex,
It
How-
falls through the cracks.
but how did that deal, with, remember the camper over my way that was gonna be on the farm?
yeah,
And then they just plunked it there, and the neighbors were very upset because
Right.
it was almost in their backyard.
yeah.
And how did that get
this
dealt with?
This is part of why this section of the regs needed to be updated, because we just didn't have clarity on how to
Okay.
deal with that situation, which was an odd one,
It
but.
was, yeah,
um,
and it's kind of like what John's, it fits what John's talking about too, I mean, a little house.
Yeah, so the way this would deal with that would be to say, if this is an RV, which in that case it was.
Yes,
If you're gonna be there for less than 90 days, you're fine. If you're gonna be there for 90 to 180, you need a zoning permit. And once you hit 180, get rid of it. You can't live out of that. for
Cause they
more
were
than-
planning to live
Yeah,
there,
they were-
that couple,
somehow
like,
they
just
were
like he's
gonna-
talking about.
Right,
Yeah.
that's what,
I don't know how through the winter, because it wasn't a tiny
didn't
home
make
that was
sense.
insulated and all of that.
Well,
It was a,
they were young and-
1965, pull behind,
They were dreamers.
yeah.
Maybe.
Well, not in today's,
not in today's terminology.
not in the
they
DACA
weren't
sense, but
dreamers.
yeah.
But the neighbors sure were upset because there was something like a generator or something running all the time and it drove them insane. That's what I recall.
So I don't have any changes to make here except for James's suggestion to 520.2 number 3 to increase that to 2 weeks, less strict. If upon thinking about this further, especially with the tiny home thing, you think that there is additional language that should be either in the definition of a camping vehicle, or perhaps we need to have a definition of a tiny home in the regs, since they are
Yeah.
in vogue and everybody knows what they are now, let me know and I'd be happy to work on adding that.
I think John has a good point about that. I think you're gonna hear more about it.
And-
Well, let's see, we've got, let's see if any problems crop up with the language that we have, maybe.
If I
How
showed
would John-
them this draft
situation
language,
that John
they will have
How would that
problems
be covered
I
in?
think you're right.
when they read that
zoning
180.
permits, or-
So if,
They're not a camping thing, so.
yeah, so that, what Joe said,
But-
if it was the situation
Where
John
do they go
described,
in our regulations?
that would not be a camping vehicle, they're gonna live, it's a
like an
tiny home
accessory.
under this definition.
Well,
Meant
except that
for,
it could be
not
the only-
meant for
the only
temporary
unit of
living
property,
quarters,
which
but
means
meant for
primary.
permanent
Which
habitable
that's-
space.
Which would make a hell of a
Different
small
They
second.
would need a zoning
you know.
permit as a house, or as an accessory apartment. It'd be great for accessory apartments, these tiny homes
said-
are the perfect
said
thing
that.
for accessory apartments.
Yeah, and from my reading of the larger world, young couples are looking for a way to have something like their own home, which isn't very big. They don't wanna buy even a 1,200 square foot
Right.
home. They can't get financing for, they don't have the income to borrow money, et cetera.
Right, and in the
This
old days,
they
that
can
was just
do.
called a mobile home,
Yeah,
and nowadays, because of HGTV, they're called tiny homes.
Right.
Yeah,
And they're marketed highly.
right.
If
Could
you
we
watch
just
television.
say in the camping vehicle definition that a tiny home could be used as a camping vehicle?
I think it just has to be one or the other, it can't be both, and.
Right.
well, that means they have to take it off its wheels. And in
That's not
fact,
hard to do.
well, in this case,
You think it
the
is?
frame is what the house is built, the tiny home is built on, and the
Right.
frame includes the suspension and
Okay.
3
You don't have to take the
axles
suspension off, you just
and,
take the wheels off. I mean, jack it up.
They used to do that years ago with
Sure,
mobile
yeah.
homes, cause they have wheels and then they take
Yeah.
them off, right?
Yep.
Yep.
So,
It's the mobile.
I
think
think
you
you
need to
get
come up with
into
a-
all sorts of
ooh, yeah.
interesting, I mean, I just saw something the other day, and it was a tiny home, but it was floating in a pond. I mean,
yeah,
I
put it
mean,
on a barge, put it on floats.
Yeah.
so how many different kinds of things you try to anticipate? We just ban hippies.
These folks
Especially
aren't-
the-
these folks aren't
I know.
For a definition for tiny homes? Yeah, I guess you're right. All right, I'll put that in there to do, make a definition for tiny homes.
Whoa,
And you've got a point somewhere then within the other regulations that we're creating, what affects tiny homes? What part of these regulations affect tiny homes? Is it just
Well,
any residence, period?
I think it's just gonna be in this camping section, right? Cause otherwise, if it's not being used as a camping instrument, then it's just a house.
Yeah, so
So
It
regardless
gets
of whether it has
regulated-
wheels on it or not,
it
it's
gets
just.
regulated
it's just
as
a
if
house.
it were a house. And all of the parts of this that apply to houses.
Would apply,
Would
yeah.
apply.
That's what we tell
Or
people who come in
accessory
the
units.
office. They ask about tiny homes. We had a lot up on, Texas Hill Road, very, very small lot,
Yeah.
power line running right through the middle of it, and lots of people, it was being marketed for like $6,000 because
Yeah.
it was, next
hard
to
to use.
hard to use. And we had so many calls from people who are like,
Yes.
I'm gonna build a tiny home with a composting toilet. I can do it, right? And we're like, no, it's a house. You need a septic permit from the state, and you need to have a water supply, and it's a house. Just because it's small doesn't mean it's not a house.
Fortunately, the abutting neighbor finally bought it, because I just had some communication from her the other day.
Yes, yeah. Although I'm meeting with her next week to talk about whether it could be built on, so.
Oh, really?
Yeah.
Okay.
Have to get you out of it. Alright, apartment.
Yeah, there you go. I thought it couldn't be a house because it was, unless you could have, there was an issue about the septic and the water being too close or something. When it's
Okay, so
that
did we
tiny.
beat that one up, and now we can go to where I thought we were going, which was 521. The next section, which I think is the affordable housing.
Zoning.
Yeah, inclusionary zoning section. So let me get to that place. Sorry for the screen shuffle here. And I'll use the track changes function so that I don't miss a change and fool you. All right, next change. Okay, so in this section, which is up on screen highlighted, we are listing the incentives. Here, I'll scroll down so you can see it. These are the incentives for the required inclusionary affordable units that we compel for larger projects in the village area. And we were very excited when we first created these regs to make sure that, developers weren't that they were held, maybe they weren't held completely harmless, but that we were trying to give them all the possible benefits so that these units that they were being required to build wouldn't sink their projects. Two of those benefits had to do with our wastewater allocation fee and our connection fee for municipal water and sewer. And the select board has decided that's not an appropriate policy. They think that affordable units should be required to pay full freight on water and sewer fees, and that if they want to ask for dispensation, they should have to come before the select board and request it the way that the water and wastewater ordinances have read for a long time. So they wanted this stricken from the zoning, because the zoning doesn't agree with our own water and wastewater ordinance, so that's why it's proposed for deletion. Okay, moving right along, the next change is not in that section anymore. We're in section 5.22.2. And I think we already talked about this in regards to another section that had to change. We cleaned up some language in section 5.6, design standards for commercial industrial uses, with regard to front yard parking requirements. And I think you already discussed this, and we're okay with the fact that gas stations are a bit of an anomaly, and that allowing there to be parking between the fueling island and the station itself, which is technically in the front yard, because the station defines the front yard, not the fuel island, that was okay not to hold them to that standard. So that's what this does, is not hold them to that front yard parking provision. If you're still okay with that, the next change, where did it take me? Should be 5.27.3. And this is our, the section we added very recently with regard to stormwater control. And it was our feeling in the office that we created an unintended loophole when we adopted this, in which projects that were creating less than 10,000 square feet of new impervious surface no longer had to demonstrate any stormwater control, and that was not the intent, I don't think, of the planning commission or the select board when you adopted this. So we're just clarifying that. And how are we doing that?
But isn't some of that governed by the state anyway?
Not at this
Not-
size.
Not at
that
this,
size.
yeah, not at this size. The state only triggers at 1 acre of new impervious surface, so 43,000 square feet. And this language that was adopted a couple of years ago brings it down to about a 1/4 acre for Hinesburg. So we've reduced that trigger.
But if it's a business, it's a little different.
Well,
They do the
depends.
type of business.
It depends. For businesses, existing businesses that have existing impervious surface, it is different at the state level. But for new development,
Okay.
that's the state standard. Yeah, so that first sentence in 527.3 number 1 is what's intended to do that. It basically, yeah. It says that if you're less than 10,000 square feet, you still have to address stormwater control and treatment. And then it keeps all the language that we put in about those projects that are over 10,000 square feet.
Yep.
So, let me see, did we do any other changes here that, all of these changes relate to that closing loophole. So if you're okay with that, I'll move to 529, which is the outdoor lighting. And my brain tells me that we talked about this already, because I think we had a meeting where I was like, this is a big deal, let's just talk about this. So, can we keep going? You'll see all this again once we have a final version ready for public hearing, but
So last time I remember this, we were arguing about height.
Right. I was arguing for lower height.
There's a lot of red.
yeah, it's an entirely new section of the regs. So I have notes from those previous discussions, and I will work those into the next draft. I have not worked those
Okay.
into this draft yet, so
So we'll go back over.
if you have
these.
new comments, I can take notes on them tonight, but otherwise, wait until the next round, and then you can see it again.
Some of these, Alex, I think it's just format are bold and others aren't. That doesn't mean anything.
Right, so we'll
Right.
need to make that consistent. Sometimes we do headers that are bold and
Yeah.
others that are not.
Yep.
Okay, so you'll see this again, but moving along from 529, let's see if we can get through this. Ooh, I did make a couple changes, but let's not talk about those yet. Okay, so on to section 8.2. We're almost done with the zoning. This section talks about the Development Review Board, and there was some language in here that was just dated. Section 8.2.2 is proposed for complete deletion. This refers to the Development Review Board's process, electing officers and such. The DRB has its own rules of procedures, which they've adopted, and the Select Board has also sort of blessed. I don't think that we need to repeat any of that in condensed form in the actual zoning regulations. We have a separate document that deals with that.
Is this statutory at all? Do we need to worry about the state telling us we gotta specify this?
In our zoning.
No, the zoning is not required to include this. The state, state statute does compel certain levels of rules of procedure, but we've dealt with that in the document that the DRB actually has adopted as a separate standalone document. Let's see, why did we make the change to 8.2.2, the new version? Let's see. Administer the regulations with due regard to the town plan. Oh, so this is not substantive. The section that is stricken has been relocated to the sort of non-numbered section. I think Mitch was the one who pointed out, that's sort of preamble. It shouldn't be a numbered item. It's saying the same thing, so.
The parentheses number 1.
Correct.
Okay.
So, moving on from that, the next change, 841. This section was completely wrong in several regards. And so we're updating it to be clear. Nobody files their appeals with the secretary of the DRB. We have a professional planning office. We receive those appeals and then process them accordingly. So it just reflects that. And the number of days that people had to file an appeal was just not correct per state statute. So we've modified that to be correct. It's 15 days. That's what people have. Once you've, if you're interested in appealing a zoning administrator action, you have 15 days to do so.
And then the hearing has to be within 60
Within 60 days, yep, exactly.
Ooh, we're almost to definitions.
We are. And there are quite a few changes there, but maybe we can.
I am so excited because it means we're almost done.
All right, so one other change that isn't in your summary, but is in the document up on screen, 843, we're just calling the environmental court by its proper name. It changed its name. It's no longer called the environmental court. It's Vermont Superior Court Environmental Division. Not a substantive change, but there, I showed it to you. Okay, on to definitions. So, as we discussed previously, the definition for accessory use and structure was eliminated, and because we have expanded that specific section of the regs, and it's all dealt with there. Peter was the one who said it's too confusing, put it in one place or the other, so, that's why that's eliminated. The next change in the definitions is building height, and this is a very substantive definition change. So you've already talked about all these things, I think, this one included, and wanted to see it happen, but to refresh your memory, for forever, we have defined building height as the vertical distance from the average finished grade to the highest point of the structure. No matter what side of the structure you are on, you measure from the average grade all the way around to the highest point. And I think it was Rob Bast, who's an architect, who said that's not the way it works with the International Building Code that most communities use, and it's not the way it works in several other municipalities. And he was right. And so I worked with him on and he helped me understand the code. And so that's what this change reflects. So instead of measuring to the highest point, we are measuring to the average height of the highest roof surface. So imagine you have a house with a simple peaked roof. It's easy, the two roof surfaces are the same, and so the average height of the surface is the midpoint of the roof. That's easy, right? Imagine a house with multiple roof surfaces. The Mead house across the street is like that. Well, you find the roof surface that is the highest, and you take the average height between the top and the eave of that roof surface, and that's where you're measuring to. And the point of this is that our current definition penalizes peaked roofs, and we want peaked roofs, and it sort of encourages flat roofs, and so this revised definition doesn't penalize those peaked roofs.
So can you help me with average elevation of the finished grade? Would that be the grade on the side that the average roof occurs on, or would that be the average of grade around the whole perimeter?
Yeah, around the whole
Right.
perimeter.
And is it the grade 1 inch from the building perimeter, 1 foot from, because, right?
No, it's right at
at-
where the intersection of those two surfaces
Yep,
occur.
the building, it's at the building, yep.
All right,
Isn't it where we got into trouble was if you had a house and then you had a walkout basement?
Well, we didn't
On the
really,
end of the house?
we didn't really get into trouble, but that's a common
would-
situation, and so that's why you have to use the average grade,
Because
because,
you'd be more than 35 feet.
right, because one side of the house could be very, have a small
Oh.
profile, and the other side could have a very tall profile, and we want to allow for that.
Right.
And so that's why we use average grade. I think sometimes the fire department would appreciate it if we didn't do it that way, and nobody could ever have a house that had a face that was very tall, because it's hard for them to get to, but that's not been the practice, I don't think, in many communities. A lot of people have walkout basements with a 40-foot, elevation on that side. It averages out to be okay. Anyway, that's the definition change. Did you have any thoughts on that? We have two architects in the room, so is it okay, you think?
That makes sense.
Okay. The next change is, on your list, is campgrounds. Let's see if the track changes says that. Yes. So this is a good reminder that if I'm gonna change it from 3 days a year to 2 weeks per your earlier conversation, it needs to change in this definition section as well.
So this is a little confusing. So place of business providing tenting or camping vehicle accommodations, whereas camping basically said, whether you're charging or not.
Right.
Even
Yeah,
if
the-
not-
Okay, all right, I'm reading the red.
So,
Alternatively, any parcel, okay, all right, I understand.
okay. Change to 2 weeks. All right, so moving right along, then we have camping vehicle as a definition change. We already talked about that. I gotta do a tiny home definition. Next, is the definition of commercial. Surprisingly, we've never had a definition of commercial in our regs. So this is one.
This would allow it to be a combination hair salon and attorney's office.
Sure.
You could go
We
in
have-
and
this is
have your
not
hair
something-
done while you were getting,
This is not something we've had any issues with. There's no
Deposed.
problems related to this.
Yeah.
This was just something, I think Mitch pointed out, like, why isn't there a definition of commercial when we use it in the reg?
Yep.
It comes right out of the standard planning dictionary stuff that we refer to. The next one is, on your list, is dwelling unit. That's up on screen. Oh, yes, these housekeeping changes consolidate the terminology that we use to refer to bed and breakfasts and such, and the definition of dwelling unit used to talk about tourist homes, and we've eliminated that term from the regs, because it's archaic. So that's a simple change there for consistency's sake. The next one is a definition of finished space. And this is, as indicated in the summary, a new definition to codify our longstanding practice. And we're making some other tweaks to another definition that makes it necessary.
So finished basements don't count as finished space?
if they're not conditioned.
And what is, can you give me the definition of what conditioned means in this case?
Heated,
Heated,
yeah.
okay.
Do we want to say heat?
Because you do mention non-portable heat source in the in the sentence before that.
So, yeah,
Wouldn't it?
what this is saying is that finished basement and attic space, it can be finished.
Right.
To be finished, it has to be conditioned space, has to be heated, and typically has wallboard and flooring,
Right.
in addition to that. So the test is, you have a basement, is it heated? Then it's finished.
And that means the same as living space that we, in our work, we call it.
Yeah,
living space.
livable area essentially,
Livable
for the
area.
assessment, for
Okay.
assessing side of things.
Would it make
Would,
sense
but
to
John's,
just
yeah,
say heated?
would it be clear to
it
everyone
could
if,
be air
if the word
conditioned.
conditioned
Yeah, I
wasn't used
didn't
and it
know
was?
what condition meant.
Yeah.
I'm showing my ignorance here. I just didn't get that.
Well-
Fairly common, and it's becoming more common because we're not just heating anymore.
We're also
Right,
air
So
yeah,
conditioned,
that's a
air
good
conditioning.
point.
right.
Right. It's
So
a,
you
it's
could
a,
say
it's a
heated-
term that's used in this realm, but it's not necessarily one that a layperson would understand. I could put a parentheses.
Parentheses would be fine.
Yeah.
Temperature control.
Conditioned space, we spray conditioner.
I just haven't heard that before.
All right, so
A
in,
fan, you could have it, right.
we're in.
A handheld fan, does that work?
If you're
No,
paying the
it's
person
not.
who's
It's,
doing it.
that's portable, so it
You
wouldn't
have
work.
some
Wouldn't work down, it's
slaves
portable.
with big
Bring it on.
palm fronds, you know. Turn on the air conditioner. This is heated, by the way. Sitting in front of this,
Yeah, it
you're
blows,
heated.
it blows.
It's blowing
Feel it?
from the time you first turned it on. That lamp
Which,
is
which in
producing a
another,
lot of
which
heat.
probably by your next meeting will be more appreciated, because we'll be
Yes,
in the heating
right,
season
right.
then.
This is a finished space.
Okay, so that's finished space. The next definition that we touched was, as noted above, the livable floor area. And so this is a pretty significant change. We included the word finished, which is why we wanted to have a definition of what finished space was. but we tried to simplify this definition. I have always had a hard time understanding what this meant. Peter had to draw me a picture when he retired, and then I had to have him come back like 6 months later and draw me another picture. I still didn't quite understand it. Mitch understood it, but after talking about it, he said, listen, it doesn't have to be that complicated. So the way the new language reads is that for attic space, this was the complication, sorry, it was all about attic space. For attic space, under the proposed change, for the attic space to count as livable floor area, it has to have a clear height of 6 feet or more from the finished floor level to the ceiling. Under our old,
That's on the one.
under our old regulations, it talked about, it talked about the roof rafter and the ceiling height, and it was trying to get after, the concept of knee walls and open, that's hard for me to explain, but it was complicated. So we thought it could be simplified to simply say, if you have an attic and it has 6 feet or more from the floor to the ceiling, that portion of your attic is livable area.
Except it, what this does is it flies in the face a little bit of the requirements of the building codes that apply in the state of Vermont.
How so, Rolf?
Because it
6
needs to
feet
be
is
more
allowed.
than 6 feet.
Yeah.
It needs
6
to be
feet.
7 feet.
I didn't think Vermont had building codes.
Oh, yeah.
Oh, yeah.
We do. We just don't always pay attention.
Well,
Really?
we don't have building codes for single-family homes.
No.
There's no building code
Right.
that people have to build to for that, except
Right.
for energy efficiency. They gotta have,
Okay.
they gotta meet the residential building energy standard. If they wanna build, a house that, with a roof rafter structure that's gonna cave in on the first snowstorm,
They let them do it.
they let them do it, right? Unless I'm wrong. That's always what I've told
What
people.
about in places where the state code does apply, like Burlington?
Well, so Burlington has its own
That's
building code.
Burlington.
Colchester does too.
Yeah, there are other towns.
And my
that
understanding
do.
is there are codes even in Hinesburg, state codes that apply in Hinesburg for multifamily,
Multifamily,
rental
right.
units, that sort of
Right.
thing. But the bulk
We're
of
talking
the
about
buildings that happen in
single-family.
Hinesburg are single-family homes. I wasn't aware of any statewide building code for that. But even if
Jesus.
that's true or not true, if you think it should be 7 feet instead of 6, that's an easy change to make here. Our office just wants clarity and wants to be able to, our residents to have clarity about when does an attic count as livable area? How much of a ceiling do you have to have?
Can you define clear space for me? So I'm thinking of like a Cape Cod house or something like that, where, you can have an attic, that's finished, right? And certainly the center of the ceiling will be one height, but if you go, to one side, sooner or later, you're gonna hit, the rafters, and then you're gonna hit a knee wall, right? So is clear height, like the height at the center of the room, the center point
Or
between the knee walls?
average.
Or is it,
So the way we used to interpret this, actually, now that you're saying that, maybe this needs a little more work, at least with more words. But the way we used to interpret it was, you take the portion of the attic that has that height, and that's livable space. On the edges where the roof line comes down and you're below that height, it's no longer a livable area. It doesn't count.
it can be finished, it can be insulated, wall boarded,
Right.
right, whatever.
You can have a beanbag chair in there that when you get up out of every time, you hit your head, and we don't count it
That's
as a livable.
consistent with the way buildings are appraised.
Yes, I was just gonna say, that's how we do.
What-
We
is
move
there a-
in until it is,
What height? What's your height? Is it
I-
7? Like
I think it is
Rolf
7
said?
feet.
I don't remember, cause I haven't actually
Well,
gone out and measured for a while, so I don't remember, but I certainly can find out.
So even if you had like a room on a main floor, I'm thinking of my house, if you had a room on the main floor, but it's a salt box roof, so
It's a 1.5 story technically, that's how we look at it, like there are 1 stories, 1.5, 2 stories. So if you have what Alex is talking about, like just 4 feet out here, that doesn't count as livable
Huh.
space.
interesting, okay.
Yeah.
Still usable,
Usable,
but
but
not livable.
correct,
Yeah.
Unless you're really,
absolutely.
really short. I
True,
mean, some of us wouldn't have such a problem.
there you go,
Right, you'd have
Maggie.
more
I'm
livable
saying.
space.
You'd
right.
probably still be like this.
Or if you're extremely flexible.
Right. Or you put the head of your bed under the low area.
Yeah.
I think whatever.
I think
but
it is
the ar-
7 feet though.
Yeah, I think
I have
seven
no
is
problem
the,
with that if
is
you wanna
the
call it 7
minimum.
feet like Alex said.
7 is the minimum.
So I'm happy to change it to 7. Do one of you two wanna look it up and get back to me as to whether it actually is 7?
Okay.
Okay, cool. That would be helpful. Cause I trust you guys to know where to find that better than I would be able to find it. And that is the definition of livable floor area, okay.
And apparently, we need a definition for foot candle.
Apparently. Cause we got it.
'Cause
Right,
it's a
so-
green unit.
Has to
So
do with lighting.
Foot candle is referenced in the outdoor lighting section, so I figured nobody knows what a foot candle is, we better have a definition of it.
Isn't that a candle that's at least a foot tall?
No, it's not what it is.
Right.
So yes, foot candle's the next one. And
We'll get that.
Gas sta- we have a definition for gas station.
right, the next one after foot candle, hold on, let me catch up in the document here. Yeah, you can't change the foot candle definition, that's right out of the textbook. But gas stations, that's fair game. So previously, we just said a gas station is a motor vehicle service and repair facility, which is the old-fashioned way of thinking of gas stations, because they all had shops attached to them. Well, now most of them don't, right? They're the Jiffy Marts and the mobile, so this definition just reflects that.
Now, if I were Elon Musk, I might object to calling it a gas station, and I might want you to call it a fuel station. And you are not filling up a tank, you are filling up batteries.
But I don't think
And
there
there's
are
gonna
any electrical charging fueling stations yet, right? Because they don't
They're
charge fast
coming.
enough for anyone to drive in
Right.
and do anything.
But they're coming.
Maybe. Well, we'll change the regs, John,
Yeah.
when Elon Musk comes to Hinesburg. So that's gas station. The next one is green infrastructure and green stormwater infrastructure. These are terms that are used in the town plan and have definitions in the town plan, so I thought we would just make them the same in the zoning. There isn't any particular problem that these definitions are solving, but I thought it would be good for consistency's sake. If you're okay with that. After that, the next one is the lot area definition. And I think maybe we already talked about this somewhere, I have this memory of that, but in any case, this definition has been around for a long time. Hinesburg has always excluded, access roads and easements from your calculation of lot area, so you sort of get penalized if you have frontage or you have a road running through the middle of your property, your lot's smaller than you think it is. I'm not sure why we do that, but that's the way it's been done. And so it's mentioned private easement, and there's been confusion in the office at times about, well, what if it's an easement for something other than access, like a utility easement
Power
or whatever? And I don't think that was ever the intent of this, so I think striking that wording retains the intent without losing anything. So that's lot area,
So,
minor
public
change.
street, proposed street, would that street be a proposed public street or a proposed private street?
Oh, that would be either. It's not specific, so it would be either.
So if it's existing private, well, I guess you could call that,
Then we would assume it's a right-of-way
A
for ingress or
right-of-way.
egress. But if you want, Joe, it could be changed further to just say within the boundaries of an existing street, proposed street, or right-of-way for ingress and egress. The fact that we have public street first doesn't seem to add anything to that, since we say the more
Yeah.
general right-of-way after that.
Yep.
Would that maybe make it clearer?
yeah, I mean, the public street and then proposed street kind of threw me up. Because
Okay, I can change that, that's easy. Lot area, change, public street to existing street. All right, the next one is lot coverage definition. As noted in the summary, this is just for clarity. The current definition, I don't know why, but it listed certain types of uses. Lot coverage is the same regardless of what the use is, whether it's residential, commercial, what have you. And then the last sentence at the end was tacked on to make sure we're differentiating between lot coverage and impervious surface. They get after two different things. We would want to count sidewalks in the impervious surface estimate. We don't count sidewalks as a pedestrian amenity in lot coverage because I guess we don't consider them to be part of the developed landscape, and we don't want to penalize people for having them on their site when it comes to our maximum lot coverage allowances.
But not so with impervious areas.
With impervious areas, if it's gonna run off, it's gonna run off, and they need to count it. Yep,
Yep.
exactly. So that's lot coverage. The next change is low impact development. And we had an existing definition, and this is just cleaning it up for consistency with the town plan. We've made some changes in one document, not the other, and this brings them together. I don't think there's no policy change here, it's just for consistency. If you're okay with that, the next one is, again, like foot candle, a definition for the term lumen. You all know lumens now when you buy light bulbs, right? You don't look at the wattage, you look at lumens. Probably still look at wattage, don't you? Yeah, that's why on most of them, they talk about the wattage equivalent, because all of us old people are, haven't figured it out yet.
60 watt
Yeah,
bulbs.
how bright is
Light
it?
fixtures tell us we can only put a certain wattage light bulb.
Well, that's true too, yeah. Anyway, so you can't change this is out of a dictionary. The next one is modular homes. And as the summary indicates, this is to help differentiate between modular and mobile. And then we have some changes right next to that to the definition of mobile homes.
Should that say does not include camping vehicles or tiny homes?
I will ponder
I
that,
don't
John.
know.
I'm
I
gonna,
don't know,
you're-
maybe not.
you have forced me to think harder about the tiny homes, so, definition and look at contingencies throughout the regs, so
How it
I will look
applies.
through there.
Yep.
I'm not sure. And then the change to the mobile home park definition. Again, this is to be consistent with state statute. I'm not sure where our original one came from. It's not what the state uses to define a mobile home. I mean, a mobile home park. So moving right along. Next one on your list is motor vehicle service and repair facility. And again, this change is simply to recognize that they don't all have gas stations attached to them.
So there might be a situation where it's both
Yes,
a motor vehicle service and repair facility.
yes.
And a gas station.
Similar to, well, that would be Heart and Mead.
Heart and Mead.
But Jiffy Mart was an example of a different flavor. They are both a gas station and a restaurant. And a convenience store? I don't know. We're getting rid of convenience store now, but in the past we had that. So yeah, they
Yeah.
are multiple uses, which is fine. Okay, we're almost there. Path is the next one. Oops, no, wait. I stuck one in here that I didn't put on the summary list. So here, so as not to deceive you, in the definition of outdoor recreational facilities, which is up on screen, which is just before the definition of path, I've struck out the word customary. The sentence currently reads, such activities shall be considered customary accessory uses and shall be deemed permitted. It's referring to recreational use of certain sorts. And we used to have the word customary because we had our accessory use section talked about customary accessory uses. In this new version, we've deleted the word customary, so this is just being consistent with how we phrase things elsewhere.
So any accessory use is permitted.
Say again, Joe?
Well, so customary is a modifier on accessory,
Correct.
right? So we took away the modifier.
Right. Accessory uses as
It
they are,
says anything deemed an accessory use would be permitted.
well, it says such activities shall be considered accessory uses and shall be deemed permitted. So the such refers to the sentence before that, which talks about outdoor rec activities that require no substantial alteration or maintenance of land, such as green space, parkland, primitive hiking trails. So it's only those that shall be deemed permitted, not every other accessory use you could think
All
of.
right, thank
Yeah.
you.
I mean, some mountain bike trails are quite, require quite a bit of maintenance and are, substantially alter the,
Yeah.
You're right,
Yeah.
actually, and so
I mean, I'm
do
looking
vast trails.
yeah, well, fast trails disappear.
Oh, but they require a lot of maintenance.
Yeah.
They put a
They're not-
groomer on them, every week. But I know what you're saying. They don't impact the land. Okay, so you can monkey with the rest of this. This was something that was done a while ago. I hadn't proposed any changes here except just taking the word customary out. But if you think there's an issue with that, we
No,
can,
just making a comment.
okay. All right, well, if you don't want to monkey with that, the next change is under path or pathway. Again, why did we put this in here? Mitch noted that the word path or pathway is used, I think, in the stream setback or buffer provision where we allow paths within the buffer as a conditional use, and his comment was, oh, what's a path? And I said, okay, fine, we'll add a definition. So I don't know if this definition works for you guys. You should think about it. It's new.
Did you find it somewhere?
I referred to several different planning dictionary kinds of things, but I don't think this one was pulled out of a dictionary, so you can change this one if you think could be improved or has a problem.
I actually like what it says.
I don't know whether we need to address it, but I know that in some of the land conservation documents, we say that you either can or cannot ride a horse on one of the paths.
Mm-hmm.
I don't see horses mentioned in here. You can.
They would be included. Well, the first sentence says a walkway or route designed for pedestrian usage and sometimes other types of conveyance. It uses bicycle as an example, but it could be anything
Could be a
else. Could be a
horse.
snowmobile, an
Could be a
ATV, a
snowmobile.
horse,
Could be skis.
unicycle, yeah.
Okay.
Okay, so if no suggested changes on that one, the next definition change is setback, road, which just refers you to the definition for street, so there's no real substantive thing happening there. And then the next change is in the definition of setback, and there are a couple things going on here. We've added the term ramps, so as to not include them as
Yep.
part of the building phase. We don't
Yep.
think it's fair to have people who need ramps, have to keep them set back if we don't require stairs to be set back. And then, We added a note on the end. I'm trying to remember why we did that. Private right-of-way serving as a principal means of vehicular access to a single, oh, yes, sorry. So this has been a bugaboo for a while. Where does the front yard setback begin on a shared road? So like I said, on public streets, we have a front yard setback and a frontage requirement for lots. On private streets, we do as well. So the question became, well, what if you have, so as that shared road serves 6 houses, and then 5, and then 4, and then 3, and then 2, and then it's just a driveway to the last house and it's not shared anymore, where's the front yard setback cut off? And then the second scenario that was a bugaboo was, what if you have a house on a lot and your neighbor has a right-of-way on the far side of your lot to cross your lot to get to their house, which is out behind you. They're on a separate lot. You're not sharing anything, but they happen to have a right-of-way that comes across your property to serve their house. Is there a front yard setback associated with their driveway? And this is meant to clarify that there is not.
Okay.
We don't want there to be front yard setbacks required from single-use accesses like the end of a road or a right-of-way across somebody's property. At least, that was our thought in the office. If you agree, then we're good. That's the way we've been interpreting it for many years. So we thought we'd write it down and codify it.
This says, refers to the nearest distance between a building face.
Yes.
What about a structure face such as a retaining wall? The example I can give is on lot 15, the Hannaford, proposed Hannaford project has a retaining wall
Yep.
on the north side, right on the property line, where the back of
Dark Star.
Dark Star is.
Yep.
Why isn't that retaining wall a structure? There are also retaining walls not built of concrete, but of large stones on Thistle Hill, for example.
Yeah, because in our definition of structure, which is a little bit further down, we've never considered retaining walls to be structures. We've never required permits for retaining walls. So we wouldn't measure a setback to something that isn't in fact considered a structure that you would get a permit for. So we could change that, but that, as part of these housekeeping changes, that wasn't part of what we were proposing.
They are significant physical elements in the landscape.
Sure. Well, similarly, we don't require permits for fill. So if somebody wants to, build a berm or whatever, we don't require setbacks for those. Similarly, fences. We don't have setback requirements for fences. You can build a fence right on the property line. And in fact, I tell people that's actually a good place to build the fence. Just make sure you talk to your neighbor first so that everybody agrees where it's supposed to go. Because the moment you build a fence into your property by a foot, the neighbor on the other side thinks they own right to that. But anyways, that's the answer. This doesn't refer to those because we don't consider retaining walls to be structures under our current regs. That could change, but that's not what this is about.
Well, they certainly have as much impact as the side of a building, from my point of view. A retaining wall, a pile of boulders that's 7-8 feet high on a property line.
You think they should be
Now-
set back?
Now I'm looking at that out my dining room window.
So that's a different discussion.
Yep.
You could have it as part of this, but that would be a significant change to the regs. And we'd have to figure out how to deal with all the existing ones that are already out there. I mean, they'd all be sort of grandfathered in, I guess. But the moment somebody tinkered with them, it might be kind of problematic. Expansion of a non-complying retaining wall, that
Right.
sort of thing.
Right.
There's garden supply and
Then you're gonna have to talk about fences. I mean,
Let's
it's,
just move on to signs.
it's like, yeah, good idea.
Well, don't lose your
Another
thought,
time.
John,
Well,
but,
I disagree with all of you.
That's okay.
okay, I will move along and, yeah, sign. I think we talked about this. So what I'm hearing is not a discussion as part of these housekeeping changes, but,
Yeah, this is more than housekeeping, I agree. It's
Okay.
significant.
so yes, another time. Maybe we'll put it on the list for the next set of housekeeping changes, or maybe it needs to be a separate thing, anyways. So the sign change is just to, we talked about this, I know we have, it's just to clarify that, the base of the sign, generally doesn't count towards the sign area allowance unless it's integrated into the sign for advertising purposes, like, it was when Saputo owned the cheese plant, they wanted to make a sign, they were gonna have a solid base, not on posts, and it was gonna have their company red colors, and Peter and I were like, well, wait a minute, that's really part of your sign, that's part of your advertising, and they said, okay, fine, but, that's where this suggestion came in, to clarify in the regs that that's the case. So if you agree with that, then that's what this is intended to do. If you don't agree with that, we can talk about it.
Seems good.
Okay.
Yeah, that looks fine.
Next. Solar installation. So I think when you adjusted the regulations, to deal with, landscaping requirements for renewable energy installations, this was one of your most recent changes. Len Duffy was the one who wanted you to do that, and you did. We did not include a definition of a solar installation, and so that's what this is. Just to clarify things.
So this would be like the one that's going in presently on McGee Hill? Is that what you're referring to here?
No,
That's-
that's connected to the grid.
That is,
Connected to the
right.
grid.
Right.
So that's not
Right.
included.
So,
Okay.
that helps me though. I sort of led you astray.
Okay.
This definition is related to everything else that section doesn't cover.
Okay.
Yeah, not
'Cause I did
connect,
know that was
not connected to the
So
grid.
that one is different than all the others we have in town, right?
No,
No, there are
most
other
most of
sections
them
that
are
are
connected to the
grids.
grid. What this would refer to would be the Estes, for
Okay.
example. If they had a solar installation on their prop, I don't know if theirs is all roof mounted or if it's actually on the ground. I've never been out there, but they're off the grid.
Yes.
And the folks at the end of Levine Hill Road
Yes.
are off the grid.
Correct.
And so this refers to those.
Okay. Gotcha.
Anyway, the next one is a change to street.
Street.
And again, this is
Just a
similar to the last
clarification.
clarification saying if it's just serving a single dwelling, it's a driveway, it's not a street. Which has been our practice for some time.
Can I just ask, the difference between a road and a street, according to this, they're the same thing.
Yes.
I think of a dirt road, it's not a street.
What's the
No,
difference
neither.
between that and a lane? Or a drive?
A lane and a dirt road. Oh,
There's a lot
Yeah.
of, it's all semantics, right? There's a lot of
Yeah.
different terms to refer to accesses, lanes, drives, streets, roads.
Circles.
We're not even consistent in the town of Hinesburg with our naming, right? There's,
Right.
trying to think of what's the good example. There's Silver Street, there's the Hollow Road,
Right.
there's
That would
Baldwin
be-
Road, there's,
Main Street,
yeah,
Route 116.
they're kind of interchangeable.
Yeah.
The 911 people sometimes
But I
think
get
they're
what you're
different.
saying. I think the
Yeah.
same way.
well, like Joe just said, it's a
Particularly
traveled.
There you go.
Right, that's what this definition talks about. So the next one are a bunch of changes to the definition for structure or building. One of the big changes is to get rid of this language that says it requires a fixed location on the ground, to simply say that it's anything constructed, erected, or placed upon the ground, or in this case, land, which is consistent with the way some other municipalities do it. Some people, not very many, but some people did try to get around the current language in the past by putting the shed on wheels and pulling it around and telling, when Peter was here, he would
They
say,
didn't want it assessed, that was the thinking.
that was part of it too. In any case, so that's one change that you can think about. The other is to get rid of a building in excess of 100 square feet, because all buildings are structures. Some buildings don't require permits. Those would be the ones that are under 100 square feet, but they still should be covered as a structure. They still need to meet setback requirements, even if you build a potting shed, 10 by 8, you still have to meet setbacks. It's a structure. And substantially increased the list of what's not included as a structure to try to cover some of the more common things that might be misconstrued. So if any of these you think should be considered a structure, holler, or if there's something that you think of that is common that should be added, holler. And look,
Only
John,
thing is,
your retaining
fuel
walls
tanks.
was added in here, so, it's a relevant conversation.
Right.
I think fuel tanks, I don't know if they've switched it yet, but I think they have to be on a slab and they have to have a roof over them.
Right.
Yeah,
I don't know if you'd wanna count them as a structure now because they have a roof over them, but I don't think it really matters.
Is that like liquid fuel tanks, all fuel tanks?
Outside fuel tanks,
Outside.
so an above-ground fuel tank,
outside,
that's outside.
I think they've waived it for a little bit longer, but they won't fill them unless they're on a
Right.
slab.
They're gonna give another year on that study, as I heard,
That was because of the,
on the lot.
they floated away because of the hurricanes and
Oh, is that why?
I think our thought in exempting them is that there are a lot of them, and, well, actually, I don't know how many there are. There's a fair number of them.
Yeah.
And we weren't
All
interested
trailer
in,
parks.
we weren't interested in having to issue permits as a structure for all these things, so we thought we would exempt them. We've certainly never issued permits for them in the past. That's-
well, they'd be under 100 square feet anyways.
True, that's true, true.
Well, that's true too. But again, this, yeah, that's true.
So Alex, under the not included list, which is all in red underlined, which is new, as I
Yes.
understand it, the last one is
Is
retaining.
Retaining walls, yes, just per your conversation. Which again codifies our practice, which is that we've never required permits or considered retaining walls to be structures for the purposes of
patios.
assessment or for zoning.
Patios. we
So-
don't either.
So you can restate your,
don't-
your objection, Mr. Kadash, and we
It
can have the
says
conversation.
here, recreation or play structures no larger than 200 square feet. You give some examples there. Those are not included. None of those require a permit anywhere else in the regulations. So saying that we don't require a permit for a retaining wall as a reason not to include it as a defined structure seems
Yeah, so there's-
inconsistent, and then
So there's two
structure-
different issues there. One is the permit, which you're right, it's not really relevant in this definition because elsewhere we can decide what needs a permit and what doesn't. But once you call something a structure, it has to meet setbacks, which speaks to your concern
my
about
point.
retaining walls. We were, with the recreation structures or play structures, trying to make it clear that you don't have to meet a setback to put a swing, on your property. Our practice in the past has been to not consider retaining walls a structure and to not require setbacks. If they did require a setback, and they were the same setbacks now that we have for all other structures, they'd have to be set back 60 feet from the center of the road, and other 20 or 30 feet from side and rear lot lines, that would pose some significant issues, for people looking to do terraced, whatever, garden space or yard space in certain circumstances. I suppose to get after the concern that you have, we could try to be more specific about the height of the retaining wall and say that, retaining walls under a certain height are not considered a structure, and a retaining wall over a certain height therefore is and needs to meet setbacks and potentially get a permit.
By talking about retaining walls, you also are not talking about fences.
That's true, because we list fences
So
later.
we don't
as-
have to get into, well, is it a fence? Can a fence be on a property line and a retaining wall not? Well,
Right,
yeah,
we
they're different-
specifically
they're
exempt
different
those.
animals.
Yep,
Yeah, I'm thinking of a retaining wall I pass every day on the way back and forth to work in Williston, and, I mean, they did it so they could support a bike or pedestrian path, and it's a really substantial, I mean, it's probably, I don't know, it's back a little ways, but it's probably 30, 40 feet high, all right? I can see instances where people, may want a retaining wall close to their property edge to support a path or a driveway or something like that. I mean, after all the culvert overpasses, I mean, it's a retaining wall, right, to the right and left of it. So,
Well, I'm thinking about the larger population, people who don't want a retaining wall right on the property line, right outside their dining room window. I mean, our obligation is not just to the individual owners, but it's to all of the owners.
Well, I understand that, I'm just trying to caution you that there are unintended consequences here, right, to deciding that all retaining walls have to be, set back from a property edge. Right, that, a lot of retaining walls, right, are for public infrastructure.
Just go to Thistle Hill. That would be a real big problem up there, because there are so many retaining walls, and I
Right.
think they're
The
lovely.
problem being that quite possibly that area should not have been planned and developed the way it was, because it requires all these retaining walls in order to create building platforms. And,
But,
the density would be less to develop on that hillside.
But is that what we really want to,
Yeah,
in a
that- I
village
think it-
landscape?
right.
Don't we want
What'd
the
you do about
density?
retaining wall
I
on the
mean,
lake?
we're not in Iowa.
I think it's lovely up there.
It's not
There's-
flat.
but-
Well, I don't want density, so.
Well, there's a place for density and there's a place for
Right.
not.
and
Right?
that's
You don't want equal density throughout a town.
correct.
You want density where you have services to support that.
Correct.
I mean, we could, I'm not sure this is the right approach, but you could, maybe Alex suggested this, limit the height of a retaining wall, and after that, it becomes a structure. Like somehow a 2-foot retaining wall, to call that a structure seems, but when you get up to 4 feet,
I define height, so I'm thinking my dad. My dad is an avocation, loved to build stone walls.
yeah.
Right, got stone walls all over, what is my mom's property now? And they're normally, they're terraced in the hills, right? So, okay, so, if I took the total sum of all the terraces up the hill, probably be 5, 6 feet, right? If I took the height per wall, well, probably 2, 2.5, right? Which one is it?
If you look at the difference between the property line and where each of those terraces are, they keep moving further and further away from the property line. The first one might be on the property line, and if it were 2 feet high, no big deal.
All right,
The
so-
next one
well-
is gonna be back a little further, and so
Right,
forth and
so
so
back to my
on.
dad's example, right, there's enough from the garden in there, so 4 feet, terrace to terrace. That's it. Not a heck of a lot, right, if you're trying to protect from
Well, what is
property
it,
line,
what
which he
are,
wasn't in this case, but,
what are our side yard requirements?
They vary.
Yeah, typically 20 feet and as little as 10 feet for smaller structures under 600 square feet.
Well, is it less
That's
also in
enclosed
the
space.
village, the side yard setback?
Yeah, actually, you're right. In the village, it's 10,
It's
regardless.
mostly 10, isn't it? I
In
thought?
the village growth area. In the bulk of town, it's 20 feet
Mhm.
and 10 feet for smaller structures.
In residential.
And I think this question, to me, it has real impact in the densely built village. Whether we allow people to terrace their land,
Let's
I
look at
mean,
the,
what
let's look at
happens
the
across
property
the
across the
road
street.
here?
It's beautiful.
Yeah,
It's Jewel.
Gorgeous.
but that's within his own property.
It's on the
Well,
property
the
line, I
retaining
would
wall,
say.
right on
the
this- right
retaining
on the
wall would be
line.
within the,
By the setback,
Property.
the setback of 1/6, or the sidewalks, right?
Yeah.
So it's in the right of way? No, it's on the right of way probably, right? Am I saying that correct?
The setback for the situation for the Russell property
Mm-hmm.
across the street is, there's a front yard setback from the center of
Right,
from the edge
okay.
of the right of way on 116.
Right, that's what I said, the
And-
right of way.
I'd have to look at it, even though it's outside of my window every day.
Right.
But, yeah, I would imagine that some of that terracing is was within that 10-foot setback from the
Right.
edge of the right of way. But I don't know how much of it.
You know, I think even isn't some of the bike path on Mechanicsville Road, that's retaining wall,
There you go,
right? No retaining wall, no bike path.
right.
I don't think we're gonna get to subdivision.
Doesn't look that way, but we could finish the zoning.
I thought
Um,
we
If,
were-
if,
we
if
were
you
at
can,
the
if you
end.
can give me a direction on this particular,
item?
I have no objections.
Do we use a height or not?
yeah, I'm still not clear on the consensus of the board with regard to retaining walls, because John's earlier comment was, we can save this for another day, but we just found the other day, it's actually proposed to be added to this, so it's relevant. Do you want me to leave retaining walls in, take it out, leave it with a height allowance, or you guys need to,
I think this needs to get talked through more.
I
Get-
think it
needs
to be
what?
Talked over more.
I think it needs to
You
get
think so?
talked over more. I think
It's an
this
interesting
is one of those where there are unintended consequences.
so
Let
then
me-
procedurally, my question is, do you want to talk about that more like at your next meeting? Or do you want to leave retaining walls in here as an additional exemption and talk about it as part of another zoning change, 2 years down the road? Those are very different procedural.
It's a big issue. I mean, I think we have some significant disagreement here.
And there are retaining walls along rights of way that belong to the town that may be built for stormwater control. So there are reasons for retaining walls, but I don't think all retaining walls should be exempted. I think there are different
Well,
situations.
I think the smithing of that is more than housekeeping.
I think so too.
Okay, so I got it then. I will add it to a list of things to talk about in another zoning effort.
I think a quick look at what some other communities are doing with regard to that as a defined structure may not,
That would be
that may
helpful.
preempt a lot of exhaustive
That would be helpful.
work.
Good idea.
I notice also, Alex, if you go back to page 145 setback, there were some changes to that.
Okay?
I mean, I read that and it almost, it makes specific reference to a front yard setback on frequent, oh, wait a minute.
That's not 145.
No,
Oh,
forget
it
it,
is.
forget it, it's mentioned.
Okay.
I'd like to have that discussion, by the way, sooner than 2 years from now.
Okay. Just trying to be realistic, how long it takes us to get to things.
Well, there's one big issue which is not in these housekeeping changes, and Joe brought this up several times, several meetings ago, having to do with how we deal with stormwater. And in driving around on some of the, particularly some of the rural gravel roads, we've got situations where if we get a big storm, we're gonna lose a lot of roads, and that's gonna cost us a lot of money. And we might wanna consider doing something now to support the highway department's desires to do stormwater control along our roads. I mean, I'd like to even
So you
invite
have municipal roads
invite
program,
Bill,
And that's
Yeah.
huge,
that's a big topic,
Uh,
but I think we should not let
isn't
that
that-
That's
lose
happening,
sight of.
that's
Yeah,
happening. So what,
that's
two
happening.
things to know on that. One, the select board is working with Mike Anthony and myself and a couple other folks on updating the town's road standards so that when the DRB reviews projects, there's a clear set of road standards to apply. And when the select board gets a request from a neighborhood to modify a road in some way, they can have a consistent set of standards to apply. And they were planning to maybe adopt a version at one of their last meetings, and Mike was there to say, no, we need to put more effort into this for exactly that reason. And because at the end of this year, the state is gonna publish its requirements for the municipal general road permit for stormwater, and then the town will have to apply and get a permit for stormwater treatment along all of our roads. And so we want to dovetail those two efforts over the next 6 months or so and come up with road standards that sort of works with that. So that we are working on that in a couple different capacities.
The other thing that was mentioned a while ago, and we spent a little time on it, not a lot, I don't know if we need to spend more, is demolition of a structure in the village and, health and safety.
Yeah, I believe that you had a good discussion about that, and that's in my notes to bring back to you at the next version of this. But that wraps up the zoning regs changes. There was one definition subparcel that was deleted because we don't need it anymore due to the contiguous area provision that we're modifying. But otherwise, we're done with that round.
Okay,
You want to do subdivision next time, right? Not tonight?
not tonight.
Okay.
Ooh. All right, so other agenda items for the night. I don't think there's a lot. All right, so minutes on July 26th. The only thing I had a question on was section 511, number 2, third line down. Or maybe it was second line down, so, where was it? Maybe I put the comment in the wrong place. Yeah, forget it. Anyone else have,
I have a motion to approve the minutes.
Second.
all right, all in favor?
I-
Aye. Anyone opposed? Okay, other business?
The only one I had was, on your in the Dropbox, I put the information related to the Charlotte, town plan. They're having a public hearing on October 12th for a rewrite of the Charlotte town plan. So you're required to be notified. Consider yourself notified. If you're interested, I have their It's on Dropbox, so you can read their town plan and their report talking about how it complies with the state statute. I have not taken the time to go through it in great depth because there's a committee for the Regional Planning Commission that I serve on that reviews them anyway, and so we either did or will be looking at it. I forget which.
All right.
Do you want to tell us, can you tell us anything about the town administrator search?
I can't tell you much. I can only tell you that it's in the hands of the select board. The selection committee, reported to the select board at their August 31st meeting based on the work that we had done with the various candidates. And they had some discussion but didn't complete that. It was late at night when we gave them the update, so.
Are you saying you
Are
made
we
a
looking for-
recommendation
single
Essentially,
person?
yeah. So,
of a person to hire?
well, we made a recommendation, and that's all I can tell you.
That's all
I
you
can't
can
tell you how many people we recommended or anything else, but we did wrap up our work, made the
You did?
recommendation, gave them the background, and now it's in their hands. They're gonna talk about it again on Monday, I'd assume, in closed session. So, yeah, we're waiting a little
So the
longer.
next step is to hear from them, or for them to interview, or you can't
I don't know,
say, or-
actually, I don't know what the next step is, so,
Okay.
wait and see.
They have it.
Yeah,
They have the recommendations.
Yes.
That's where it's
Your
at.
commission has completed its
I'd like to
job.
be.
Is that what you're saying, Al?
yes.
Yep.
Yeah, motion to adjourn. Yeah, I hear you.
Second.
All right, thanks. We're done.